Self-defense is a viable defense for assault-type cases. Quite often, self-defense is what actually happened. A person has a right to defend themselves against another person's use of force or threat of imminent use of force. Quite often, this is actually what happens. In any assault-type situation, there's usually an escalation of an event, maybe a disagreement, verbal, and then it escalates to actual physical confrontation. So quite often, before a person strikes another person, they feel like they've been threatened with force. And so it is often an issue that works for our clients' self-defense, because quite often the jury believes that the person was entitled, that they were under imminent threat of force from another person, or they have a reasonable doubt thereof, and so they find the client not guilty. Self-defense is a very good defense in assault cases. Challenging the prosecution's evidence is an effective defense strategy and is often successful. Quite often, just challenging their evidence, showing the weakness, showing the doubts, showing the lack of accuracy of a witness, showing just giving reasons to give a jury reasonable doubt about the evidence is an effective strategy which can be successful in criminal cases. To challenge the government's evidence, sometimes it involves just challenging a witness's testimony. That can be done many ways. Sometimes we challenge a witness's testimony by showing their motive. Sometimes we challenge the witness's testimony by showing reasons why their testimony might not be accurate, because they had been drinking, because they were viewing from a distance, because there was some obstruction in the way, because there was other noise that prevent them from hearing what they claimed. Just any way to challenge the accuracy of what they say that they perceived or heard or saw. That can be an effective strategy. There are many ways to challenge the government's witnesses through showing that their testimony doesn't prove all of the elements that the government is required to prove. So there are many ways to challenge the government's case just by effective cross-examination of the government's witnesses. Alibi is a type of defense generally used in cases involving a question about identity, who committed the crime. And so alibi means that a person basically was at a location, some other location, at the time that an offense was committed, so therefore it couldn't have been them. So it might involve showing that, for instance, in a case where that we had, particularly our client was accused of indecent exposure at an apartment complex pool and was identified by the female who was offended by this indecent exposure. But we were able to show that our client was actually sitting at his computer working at his desk for his airline employer at a location probably 50 miles away at the time this offense happened. And so therefore, it obviously couldn't be him. That's an alibi defense. Now, there are risks with alibi defenses. For instance, like sometimes in a robbery case, the defense presents the defense of an alibi. They were somewhere else when the crime occurred, so it couldn't have been them. But because that casts doubt on the witness's accuracy in identifying the client, then that allows the prosecution to now bring in evidence that they've committed these other robberies, extraneous offenses that generally aren't admissible and wouldn't have been admissible if they hadn't presented this alibi defense. So while alibi can be an effective defense, it can also have certain risks involved. Therefore, you have to have expert attorneys who know how to know if the defense can be successful and whether or not it involves risks that must be avoided. Defenses involving unlawful search and seizure can be effective and are often a good way to defend a case. Quite often, the police act illegally in searching or seizing an object. Quite often, the police do not have reasonable suspicion to detain a person before they even search that person for the officer's safety in the first place. Sometimes the officers did not have reasonable suspicion to detain a person and then search the car or seize sees something that they claim was in plain view. Sometimes the officers don't have an exception to the warrant requirement to search a home. Sometimes they don't have legal reason to seize objects that are in plain view because they didn't have permission to be in the location they were. There are many ways that a search or seizure can be challenged as unlawful, and this is quite often a good and viable defense. There are so many legal and factual defenses available to successfully defend a client, but you must have the expert representation to avail yourself of all of those possible defenses. You must have expert representation like the Medlin Law Firm.